Hello, and welcome to the Illinois LawCast, a podcast about the wisdom, wit, and curiosity of the University of Illinois College of Law. I'm your host, Chris Davies, and this episode is all about the Kimball R and Karen Gatsis Anderson Center for Advocacy and Professionalism. Joining me are Director Tony Ghiotto and third-year students Yev Kozak and Nicole Marcinkus, who were finalists in the 7th Circuit Moot Court competition hosted by the Anderson Center in Chicago. In our conversation, we discussed how far the Anderson Center has come in its 3 years, as well as how competing has made a difference for Illinois law students. I enjoyed spending time with these individuals, and I hope you enjoy our conversation as well. Thank you, Professor Tony Ghiotto and students Nicole Marcinkus and Yev Kozak for joining me today. Let's start with a little bit about the Kimball R and Karen Gatsis Anderson Center for Advocacy and Professionalism. Tony, you are the director.
I am.
And can you just give us maybe your elevator pitch as to what the center is?
Sure. So the mission of the Anderson Center is to prepare and develop competent and professional students who are ready to serve their community and zealously advocate for their clients, and to be ultimately practice ready from day one. And to do that, we kind of have three components to the Anderson Center. One is our curriculum. So we work very, very closely with the deans and the faculty here to have a very intensive trial advocacy curriculum that has a ton of offerings that cover both basic and advanced advocacy, basic and advanced evidence, and professional responsibility. The second component is, we call it the law competitions program. And what those are is we have trial team, which is basically mock trial. We have moot court, which is appellate advocacy. And then we have kind of what I call the dispute resolution component, and that's negotiations and client counseling. And starting next year, we're adding mediation and arbitration to that. So in those components, students try out, they're selectively picked. They receive academic credit. They are assigned to either a full-time faculty member or an adjunct who serves as their coach. And then they go off and compete in competitions throughout the country. Then our third component is kind of our special programming component, and that's kind of a catch-all. So we do symposiums that try to position the University of Illinois as thought leaders in the intersection of advocacy and professionalism. We host competitions. So, for example, we hosted the 7th Circuit Moot Court competition in Chicago. And we are hoping to host more competitions next year. And we also bring in a range of guest speakers, practicing lawyers, academics, to kind of talk about the bigger picture. I always like to say with special programming, it's us providing the why. Why should you put yourself through this intensive curriculum, all these competitive advocacy programs? Why does it matter? Why does advocacy matter?
The word advocacy.
Yeah.
It's right there in the title. It's one of the main things that you guys focus on.
Sure.
Can you just tell us what advocacy means to law students and to lawyers?
Well, how much time do we have? Both advocacy and professionalism are loaded terms. So for me, advocacy, I define it as how to get what you want. So for lawyers, you could practice advocacy in any component of your practice. You don't have to just be in trial or in an appellate courtroom. You are trying to persuade somebody to see something your way. And so in a jury context, that you're trying to persuade the jury or the judge to rule in favor of your client. In appellate advocacy, you're trying to get a tribunal or a panel of judges to rule in your favor. But also, too, it's universal skills. And I always say, like, at some point, you're going to have to walk into your boss's office and convince them to promote you or to kind of take a legal interpretation that you also believe in. So when I approach teaching advocacy, we're trying to do all of those things, is understand, how do we give the students the tools that they need to advocate on behalf of both themselves and their client in whatever area of law they go and practice? And so that's written advocacy, that's verbal advocacy, it's how you carry yourself, how you position yourself as a professional. And so that's kind of our big picture approach to advocacy. For the students, it could be hard, because what I find with students is, especially in law school, some of them lack confidence, and some of them have a difficult time seeing them as themselves as advocates. And so what it is for us is a way to get them to kind of build off the doctrinal basis that the law school provides them, but to get them thinking about what they're going to be doing in practice and how they're going to take the substantive legal knowledge that they gain here, but then they're also going to have to supplement it with certain practical skills to be able to advocate in those multiple forums.
Prior to coming to the College of Law, you were a Judge Advocate General with the Air Force?
Yes. So I was an active duty Air Force JAG for 12 years. And then I was in the Air National Guard for 2 years. And now I've been a reservist in the Air Force for 5 years.
How do you take the skills that you learned in that role and apply them as a professor, as a coach and teaching advocacy?
Sure, they're different. And so sometimes if I try to approach teaching and directing our program like I would in the military, nobody would follow. I'm a lieutenant colonel in the reserves, and I've been selected for promotion to colonel. And, if rank comes, people just listen to you. When I put on the uniform, there's really not a lot of second guessing or having to prove yourself. You still have to do that. Students, you have to earn students' respect. It's not just given anymore. But for me, though, what I kind of bring from it is one, I think what service and the Air Force embedded in me, the Air Force has what's called their core values. And it's integrity first, service before self, and excellence in all we do. And when I first joined the Air Force, I kind of rolled my eyes at those and didn't really give them much credence. But the older I get, the more relevant they are. And so what I try to do is always comport myself with integrity. I try to have our students do that too. Service before self. It's about our students and the opportunities that we generate for them, not about me or the rest of our staff. And then I think we should just be really good at everything that we do. And I think our students should be good at everything that they do. So those are kind of my guiding principles in my life that I try to lead the students with. And I also think, too, the commitment to mentoring and leadership is something that's not always found in academia that I bring with me, in that I do feel like I have a special duty to prepare our students and to mentor our students and to lead our students. I always kind of joke around, this is kind of like my third career. The reason why I do it so much at this point, it isn't so much for myself or for my career anymore, because I'm going to get my Air Force retirement no matter what. But it is, that 10, 15, 20 years from now, these students are going to be out in their communities, having clients, making a difference, mentoring other lawyers. And I would love for them to do that the right way, in a way that actually serves our country and our community. And that's why it matters.
You mentioned being great at what you do. And
I never said I was great at what I do. I think many people disagree with that, but...
Well, you're being humble because Pre-Law Magazine gave the Anderson Center an A rating.
2 years in a row.
2 years in a row. That's excellent. Yeah. And I know that we've had a huge rise in U.S. News.
Yes, a 91 spot improvement in the U.S. News trial advocacy rankings, the highest in the country. And then there's 2 trial team rankings. Fordham, we were ranked 9th nationally, and the Gavel rankings, we were ranked 11th nationally. In prior years, we were never ranked.
And the Anderson Center's not that old either.
We are in year 3.
Year 3. So that's a pretty incredible accomplishment to come up with so quickly. What do you, I'm not going to assume that you credit yourself. What would you credit to that kind of achievement so far?
We have wonderful students. We have students who are naturally gifted and talented. At first, I was intimidated by how smart our students are. They are hardworking. They want to succeed. They want opportunities. I think what the Anderson Center did was we were just able to give them those opportunities. We're able to give them the structure and the tools and the resources that they needed to be successful. To me, that's what I bring to the table. I just give them the resources, the opportunities, and the tools to be successful. What they do with that is up to them. And we have great students who take those tools, understand them, and use them in great ways, both in their classes and our competitions, and through participation in broader programs.
How do students join either competitions or coursework through the Anderson Center?
Sure. For coursework, that's just traditional registration. So we work really closely with Kelly Selewski and Dean Murphy and Dean Sharp to make sure that we have really good classes. We try to kind of, my goal and what I hope we do is show them the trajectory. Kind of, if you want to pursue advocacy, whether it's in the trial courtroom or the appellate courtroom, here's the road for you. You start in your second year by taking trial advocacy, then you take evidence, and then from there, there's all these electives that kind of open up for you, and you can kind of go on that. So some of that is just articulating, and some of that's on the student, too, for asking and kind of piecing everything together. For our competitive advocacy programs, That has kind of, we kind of change that up every year to make sure it's working. But usually, what we do is we do tryouts at the end of every academic year, and we do tryouts for each of the different components. And so the way that'll work is if a student wants to do trial team, we kind of give them a heads up. This is when tryouts are going to be. This is what you have to do. Usually they have to give a closing argument in a direct examination. It's before me and a couple of our other trial advocacy faculty members. So it could be very intimidating. They have 15 minutes. They walk into a courtroom and there I am sitting there and they have to do that. And moot court, we've done different things. We've done an inter-school competition where they've been selected. We've done tryouts. We're still kind of trying to find the right fit for that. But, the big thing is the students have to avail themselves of the situation, and they have to be comfortable putting themselves out there, which is really, really hard and scary. I try to be sensitive of that. But I always say, like, the first step to wanting to be an advocate is raising your hand. And it's hard to do, but just making the effort to do it is the first step.
The students that are with us, Yev and Nicole, you guys raised your hand. You obviously wanted to be part of this. Can you both tell me what was it about trial advocacy that made you want to be part of what the Anderson Center is doing?
Yeah, Yev usually takes issue one. Do you want to go first?
Yeah, I can speak to a little bit about it. I think part of it is, for me at least, was what Professor Ghiotto mentioned, the opportunities to kind of put the lessons that we learn in class to use in the actual competitions, but also the mentorship opportunities from Professor Ghiotto and from our coaches. I wanted to see how I want to see what it meant to actually represent, a mock client and to see what that looked like. And I think it's also interesting to learn from other students to see how they approach problems, how they perform at competitions. So I think visually learning from others is one of the best features of the advocacy program.
And if I can interject before Nicole talks, I just want to highlight something about both Nicole and Yev, is so that they have taken our trial advocacy courses. They've both taken our foundational trial advocacy. Yev has taken our MRSA Trial Academy, and Nicole has taken advanced courtroom evidence. But they also, they compete in moot court, which is appellate advocacy. So something I try to tell students all the time is that you can do both. So I'm going to defer to Nicole here, but I just want to highlight that they are people who have done both trial and appellate. So Nicole, sorry for interrupting.
We were in the same advanced appellate advocacy class as well, and I'm in advanced trial ad now. So clearly I like these programs a lot. I know, for speaking for myself personally, I really like to talk and I really like to argue professionally. And I figured that out at the end of 1L when we do the advocacy program and you do your brief writing. And I realized that there was an opportunity to keep getting to do that, which there's no guarantee that you get to do that at all coming out of law school, even if those are the jobs that you really want. So where this opportunity was in front of me, I just wanted it so badly. So tryouts, I was very excited for, I think went very well. I think I was actually against Yev because Yev and I end up in the same room for appellate ad very often. It was really exciting, but I echo what Yev said. Going to competitions is so fun, and it's exactly as informative as I thought it would be. The opportunity to get in front of real judges, especially when you travel, judges I would never otherwise meet. So when we went to Duberstein, getting in front of the judges that are specifically in the New York bankruptcy courts, I would never otherwise have access to these people and to all of the incredible feedback that they would give me. And then the problems that we talk about. Excuse me, I actually lost my voice this weekend at a competition. And then the problems that we get to talk about are also innovative and usually talk about circuit splits and a bunch of other legal topics. We talked about AI this year. So it's nice to be able to argue something that I think will actually be in front of the Seventh Circuit one day and sort of get a jump start on how I think that should be decided.
Now, you've been doing this for 3 semesters, so I'm asking you to go back in time, maybe hard to remember. Tony said that the tryouts can be a little rigorous, maybe a little intimidating. What was your impression of those tryouts?
I think they encourage you to try your best. Obviously, they are tryouts, so you do have to put your best foot forward. But I think the preparation that goes into it is key, and taking the problem seriously. I think it's helpful to take some time to think about what you want to say, whether it's for trial team, for a closing argument, or an appellate argument for moot court. I think getting in the right headspace before the tryouts is helpful. But I think just dedicating the time and being committed to the tryouts was the best strategy for me. So that's what I would recommend for anyone interested.
Yeah, that's very good. I think all the students here, I'm really, really proud of how both encouraging they are to each other and how competitive every single student who stands up is in just the best way. Knowing how good your friends are will make you better. I remember we were at maybe softball playoffs this spring that we were trying out, and I remember everyone going, "Great game! I have to go write my brief," and going off to the little clubhouse area and editing their brief, and then coming back for game 4. And I just remember laughing and thinking, "Well, that's also what I'm headed off to do." So it's nice to know that the people here are really involved in it. They really care about it. Even from first when tryouts are announced, people are starting to write it. It's not a last minute situation, but I think starting early is the best thing you can do if you know you really care about it. I think there are a bunch of foundational books that we use. So if you go to your professors and you ask what their baseline books are for advanced appellate ad or for trial ad, that will definitely help you figure out what they're looking for. I highly recommend reading those before you try out. I think that is what helped me because I didn't know anything going into it.
And Tony, do you want to embarrass them by sharing anything particularly remarkable they did in their tryouts?
Oh, geez. When they tried out for moot court, and I was actually homesick, so I watched them. I watched them via Zoom. Confidence. So what I always try to tell people, both in trial ad and appellate advocacy, confidence just goes such a long way, and I think most of us are faking that confidence. I think I'm still inherently not confident. Before every class, I'm like, I'm not going to be able to get through this. I'm terrible. So it is this idea of developing that sense of confidence. And I know what I look for both in trial team when people try out and for moot court is, do you walk into the room confident? I can teach trial advocacy. And our team and me can teach appellate advocacy. It's hard to teach confidence. It's hard to teach that just ability to come in. So what I remember even from Zoom when I watched Yev and Nicole's tryouts for moot court was the way that they got into that room, greeted everybody, and walked to the podium showed a confidence and a willingness to do this. And I just remember both of them are just very personable people. And so I think they even greeted the room with a smile. That shows his comfort level. And they're being humble. They were at a competition this past weekend in Chicago, a very competitive competition. And I was there with them, and they made it to the final round. And the final round was held in the Seventh Circuit ceremonial courtroom. It's this gigantic, intimidating courtroom. It's a beautiful courtroom, but it's very, very intimidating. And Yev was about to go, and he's sitting across the room from his opposing counsel, and he's just smiling at her and making silly faces. And in a very and the two of them, they're opponents, but they're kind of still being professional to each other, and they're recognizing almost the absurdity of the situation about what they're about to do. And to me, that shows, I think, humble confidence, right? I knew Yev was nervous. I knew he understood what he was about to do, that he was in this courtroom. He was about to argue in front of two literal sitting judges on the Seventh Circuit, and then the chief judge for the Central District of Illinois, as his team's fortunes rested upon him. But he had that internal confidence and that ease to go up there and do it. And that's what stands out about both of them. And that's kind of what I tell students. I'm not expecting you to be an expert in how to do it. That's what I'm here to do, is to teach you. I'm looking at, are you confident, or can you fake that confidence and kind of, to a certain degree, control a room and be a normal person? Because the more I do this, both in practice and in teaching, effective advocacy, whatever courtroom you're in, you have to be a normal person. You have to kind of, I always say, you go to law school a normal person, and then we kind of break you down and we make you think like a lawyer and talk like a lawyer. Part of advocacy is adding both of those worlds. You got to get back to being a normal person, and then you have to be able to churn through all the legal stuff that you know in your head and then communicate it in a normal way that everybody's going to understand, even if they're not a lawyer. So stuff like walking in the room and being able to smile and say good morning, or to make a dumb joke, that to me shows that one, they have the confidence, and two, they can be normal. And I don't know if I'm normal. It's a skill they have, I don't. But it kind of what set the two of them apart, and they've continued to show that throughout. There are 3 semesters of competition here.
So Nicole and Yev, as Tony mentioned, you were finalists at the 7th Circuit Moot Court competition this last weekend, early March. What was that experience like from planning to standing before these distinguished judges?
I'll let you take this one first.
Okay. This has been my favorite moot court competition. I loved it so much. I'm actually very sad to be back. I would have just keep doing these rounds if you could grade me on continually doing these rounds. Not only did I love the problem, I think I mentioned earlier, it had a bit of an AI component. I like to do things that the 7th Circuit or whatever court I'm in front of hasn't specifically ruled on before, because I like in the drafting stage to be able to throw every argument at the wall and sort of see what sticks, either legally or policy-based. And it's fun that if you think one's not working, you can sort of fall back on the other. That's a skill that I don't know how else I would have been able to develop that without the moot court program. And just being there and being surrounded by not only very good competitors, but judges that were giving me very specific feedback was just so wonderful. And, you don't get to speak to the judges a ton after you're done, but sometimes they do ask you, do you have any questions? And I don't remember another competition where the judges offer to speak with me after the round is over, which is great. So they're finished judging me. They won't do it again, but I get to ask them, did that work for you? Did this roadmap land? And then they'll say, no, try this. And I'll say, that's very helpful. Thank you. So being able to sort of engage with people that are not only so professional, but have a job that I could only dream to do one day is so great. And this is the first competition where Yev and I argued as a team, but separately. So I hadn't realized how much I had relied on Yev standing up first and sort of warming up the judges for me until I went up there and thought, oh, now they have to like
much credit.
I really don't. And I thought, oh, now they have to like me off the bat. I don't have Yev to sort of warm them up. So that was another very cool skill to develop alongside my competitors, who I could also see were doing that for the first time. So it was cool to be in that together.
Yeah, and I think just to add to that, I guess 2 things for me. I think for the Anderson competition specifically, I thought it was cool that it was, if I'm not mistaken, all 7th Circuit law schools.
Yes.
So I thought that was nice. It felt nice to just be next to law schools that we're more or less familiar with. But also, I think unique to the Anderson competition, the judges themselves were, for the most part, actual judges. A lot of the competitions, it's either practitioners or professors who sit on as judges for the competitions.
Or students from the moot
Right,
court
or even
board.
students on the moot court board for their respective school. But for the Anderson competition, it was, for the most part, all sitting judges across the 7th Circuit, both district court and, as Professor Ghiotto mentioned, the 7th Circuit. So I think the feedback, as Nicole mentioned, was the best part, because hearing what judges expect or want to hear when you get up there in real life, when you were representing an actual client, was really informative, because, I imagine we're doing this to prepare for practice, to prepare whether it be for litigation or something else. So I think hearing from judges and their expectations really kind of puts you in the right headspace to know what to expect moving forward after law school.
So the competition they competed in was one that we put on and we support. So I was not able to see Yev and Nicole prepare because I was kind of conflicted out since we were running the competition. But this was a tough competition. And as Yev mentioned, most competitions you go to as volunteer judges, and really most of the volunteers are young lawyers. No offense to young lawyers. I wish I was still a young lawyer. But people maybe a few years out of law school who are doing it for CLE credit. For our competition, we take a lot of pride in the quality of judges. So I don't have the numbers right before me, but I want to say throughout the competition, we had 15 sitting federal court judges amongst the 7th Circuit, the Northern District of Illinois, Eastern District of Wisconsin, the Central District of Illinois, and the Northern District of Indiana. I believe we had 6 judges who were on the Illinois Court of Appeals, and we had 8 attorneys, and our 8 attorneys were some of the top appellate attorneys in Chicago. So the quality of judges that they argue before, I don't think there's a competition that matches that.
Yeah, it was very cool. Both Yev and I want to practice in the area as well, so it was cool not only to get to be in front of those judges, but again to receive feedback from them and to cite a Northern District of Illinois case in front of a Northern District of Illinois judge who then asked me some very specific questions about it. And I think that was probably you, wasn't it? Or asking me, I think that cites to a different case. And what would that be? And I think, right, that would be you or your colleague. And that was so cool. And I mean, who gets the opportunity to sit in front of the 7th Circuit in the real world either, even if you practice? was very excited. I was very terrified, but
You wouldn't be able to tell.
Well, you've said a lot of the highlights from this. So at the risk of having you repeat yourself, I'm wondering what, over the 2 years that you've been a part of Anderson Center competitions, what's been the biggest highlight for you? Traveling, performing in front of these judges, being on a team, what would you say has been the best?
Give you a second to think about it.
Yeah.
It's been a lot of highlights.
yeah.
I think, go ahead.
It is repetitive, but we did get to argue in front of a few Seventh Circuit judges just last week. And that is probably that's the highlight for sure of my entire law school career. It may very well be the highlight of what I consider my future practice as well. So that's definitely part of it. But I've really, really enjoyed developing the skills in a way that is both measurable based on whether or not you advance in competitions and noticeable for me. So no matter what, when I get up and I'm 2 minutes into my argument, my watch buzzes to tell me that my heart rate's at 110, even though I'm not moving, and that I should be concerned. The first time that didn't happen was the last 3 rounds, including the finals at Anderson Center. So that was ridiculous. And I was actually waiting for that to happen. It was freaking me out that it didn't. So I didn't know that I had improved on my internal ability to stay calm, and that also that when Yev and I compete as a team as well, our experiences sort of playing off of each other's style and sort of leading one issue into another has also, I think, really improved. And I'm excited about the ability to be able to work with another future attorney in that way, because sometimes the team part of advocacy is very difficult, trying to marry your ideas to someone else's.
And one thing that we talk about, not to cut you off, Yev, is we kind of talk about the soft skills. So when I became a lawyer, I was shocked because I had done moot court in law school too. I was kind of shocked. One, wait, there's real people, there are clients. But two, there are these unwritten norms that you're kind of judged on in the profession. And sometimes those aren't always communicated to people, and sometimes you have no experience in them. Part of trial team and moot court is to expose these students to these soft skills of teamwork, of clients, of judges, of all these kind of unspoken expectations, with the idea that now when they go off into practice, they're going to know how to communicate better to their boss, because that's how they communicate to their coach. They're going to have a measured heart rate because nothing's going to compare to arguing in front of the Seventh Circuit. But Yev, I'm sorry for cutting you off.
No, not at all. And I agree with Nicole. I think arguing in front of the Seventh Circuit was kind of a once in a lifetime. Well, hopefully not a once in a lifetime, once in a law school experience, because I'm sure not many people can say that they've done that during law school. But I think the biggest highlight would have to be the overall mentorship that you get. I mentioned earlier, you get mentored by Professor Ghiotto, your coaches, the judges in the competitions. And I think being around like-minded people who are interested in trial team or appellate advocacy, client counseling, whatever it might be, I think just learning collectively from everyone involved in those competitions throughout practice with your coach, listening to, what other people's experiences have been like, both in law school, outside of law school, really kind of changes your perspective, or puts things into perspective, I should say. And so I think learning from everyone has been my favorite part so far.
We couldn't say enough kind things about the coaches and the directors of the Anderson Center and the way that they have set us up for competition. We are, in my opinion, one of the few teams that gets to walk into every competition and think that they've covered all of their bases. My experience shows that is very uncommon generally, and it is always something that we felt very comfortable with. So very appreciative of those opportunities for sure.
Congratulations on being finalists at the competition. Sounds like you did an excellent job. Thank you all for joining me today. I appreciate you sharing your experiences with the Anderson Center.
Great. Thank you so much.
Thank you so much.
Thank you again to Tony Ghiotto, Yev Kozak, and Nicole Marcinkus for joining me on the podcast. Thank you to our listeners as well for taking time to listen. The Illinois LawCast is available on all major podcast platforms, and video episodes are available on YouTube. Please email us at podcast@law.illinois.edu to share your comments or suggestions for future episodes. This episode was recorded, mixed, and edited by me, Chris Davies. Special thanks to Kelly Moss for our album art and for helping to produce this episode. Thanks as well to Krista Getke for her help in the editing process. Until next time, thank you for listening to the Illinois LawCast.